of various witnesses. That means your assistance in respect to the issuance of summons for purposes of attendance of these witnesses. Mr. Speaker, sir, as it may be noted from the motion of impeachment that has just been read before this Honorable House, these witnesses are so crucial insofar as the adducing of evidence for or in favor of the county assembly is in issue. In this respect, Mr. Speaker, sir, we invoked the provisions of the 5th schedule to the standing orders, the same being the schedule guiding the proceedings before you, honorable members, for purposes of subpoenaing these witnesses. Mr. Speaker, sir, just to highlight the essence of these witnesses, which we are seeking your guidance as to whether or not the summons were issued. Among them is one Wycliffe Ogalo. Wycliffe Ogalo is the Commissioner General for Prison Services, and it will be essential when we are adducing evidence in respect to the governor's violation.
There is a point of intervention. Sorry, Senator Orengo.
Much obliged.
I was just wondering, and you have laid out how we are going to deal with this case. The trial will not start until the opening statements have been made. I think probably if we go now into the issue of witnesses, where indeed is making an application, I think we are not there yet. I think we should finish with the opening statements and then we move forward.
Yes, I agree with Senator Orengo that make your opening statements, which you have 30 minutes, then we are yet to get there, just the way I gave direction on the other request.
Well guided, and thank you for the benefit with the wisdom of Senator Orengo. Mr. Speaker, sir, I will jointly make this.
There is another intervention. Sorry, Senator Kindiki.
On a point of order, Mr. Speaker, a further point of order based on what my learned friend Senator Orengo has raised. I think, Mr. Speaker, it will help the parties appearing before this House if you could perhaps give further guidance to ensure that we don't keep on interrupting them from time to time, such that, Mr. Speaker, that this, in my view, are proceedings of the Senate. They are not court proceedings. Therefore, when the Speaker directs that do this, you do it unless that interruption by counsel or any other party is caused by a breach of the standing orders of this House. And on that, one must say the standing order that has been violated and seek redress, as opposed to making applications left and center and every party trying to introduce applications and things they want to do at a particular point of time. The Speaker directs, do this, you do it, unless you think there is something in the standing orders that has been violated and you must point it out. Mr. Speaker, I thought perhaps for going forward for the next 2 days, that should be your direction.
Yeah, I think I'll be giving direction, and please just do what I direct. Don't be in a hurry to get to a place, a certain point. Let's just go systematically. There's a way we are going to arrive at all that. So proceed to make your statement.
Thank you, Mr. Speaker. I had indicated that with me, I'll be joining issues with my learned friend, Mr. Biko, in giving the opening statement. So I'll only take 10 minutes, and I'll reserve the rest to him. Mr. Speaker, sir, and the honorable members of the Senate, this House has gathered here today in respect to hear the motion of the Governor of Nairobi County. Mr. Speaker, sir, it shall be noted that the motion before you was moved and passed by an overwhelming majority of 88 members of the County Assembly, representing various wards in this county. Mr. Speaker, sir, when the members of the County Assembly moved to move this impeachment and the resolution for impeachment of the governor, they were not actuated with malice. They were actually moving to enhance the provisions of Article 10 insofar as the protection of the sovereignty of the people of this republic is in issue. Mr. Speaker, sir, the members of the Nairobi County Assembly moved to pass a resolution to impeach the governor, having well acknowledged the provisions of Article 10 that calls for the principles and the values of governance insofar as the question of transparency is in issue, the question of accountability is in issue, the question of good governance is in issue, and the question of the aspects of integrity is in issue. They were not lost of the fact that when somebody assumes an office and that of the status of the governor, that person must conduct and behavior, either in public or in private, must be beyond reproach. It must be a conduct that squares out with that of the sister's wife. But what are we having? We are having a case of a governor gone rogue. A governor who fails to appreciate that he's holding a public office and there is expectation for him that has been set down by the law. This house and the previous houses, they have enacted the Leadership and Integrity Act. And more so, Mr. Speaker, sir, the people of Kenya enacted Chapter 6 of the Constitution that laid the bare minimum upon which a state officer or a public officer must conduct himself. In our proceedings, Mr. Speaker, sir, it shall marvel you when we present evidence, overwhelming evidence, to the fact that the governor is not fit to continue holding this office. To the fact that the governor has not only abrogated Chapter 6 and the Leadership and Integrity Act, but he has also flagrantly misconstrued and held himself in a manner that is contemptuous to the sovereignty of the people of Kenya. We'll be posing a question at the fullness of time upon presentation of our witnesses, whether this is one person who is fit to continue holding this office. It shall be presented before you, Mr. Speaker, sir, overwhelming evidence of how a governor has plundered the resources of this country, the resources of the Wanjiko, the resources of the hustler nation that is always spoken about. Everybody must be called to the account. Be you in the hustlers nation, be you in the dynasty nation, everybody must be called to account. That is what the County Assembly of Nairobi is moving to do to you this morning. Mr. Speaker, sir, it shall surprise you how a governor, out of the frolic of his own, has moved to square out and to compete with extravagancy of Maria Antoinette. We are actually having a position of the French Revolution. The French Revolution was triggered by the extravagancy of the Queen. The extravagancy of the Queen caused the reign of King Louis XVI. If it happened in 1679, why should it not happen in the 21st century? If it happened then, honorable members, why should a governor who, by a demonstrating extravagancy, putting his daughter in an helicopter for a tour in the New York, why should it not happen today? There is a price for everything, Mr. Speaker, sir. And the price for accountability, the price for transparency, demands that the governor vacates office. Mr. Speaker, sir, it is not lost of this house the philosophy by Thomas Hobbes. Thomas Hobbes said, Mr. Speaker, sir, that human by nature, human are greedy, they are cruel, they are selfish, and they are driven by the desire to grab and maintain power by all means. That is the person we have presented before you this morning. A person who is greedy, a person of greedy of public resources, should not have mercy of this house, Mr. Speaker, sir. A person who is selfish and who wants to amass wealth at the expense of the taxpayers deserves no mercy, Mr. Speaker, sir. Mr. Speaker, sir, we shall be presenting overwhelming evidence to an extent that this house shall not be left with any other option but to agree with your brothers and sisters in the County Assembly of Nairobi. Mr. Speaker, sir, the question of good governance cannot be compromised. The question of transparency cannot be debated. The question of accountability cannot be subject of debate. Once you hold a public office, you must be able to understand that you are accountable. And what is the responsibility of the County Assembly, Mr. Speaker? Mr. Speaker, the responsibility of the County Assembly is not to adduce evidence beyond reasonable doubt at any given time. It is only to substantiate the charges. I promise you, honorable members, Mr. Speaker, sir, that the fullness of time we shall have evidence to substantiate that the governor is not fit to continue holding public office. What becomes of our sportsmen and sports ladies? What becomes of the youths when a stadium that is supposed to be constructed of concrete is constructed of scrap metals? What becomes of our youth? Is this person conscious of the intra and extra generational equity principles recited in the preamble to our Constitution? Is this person worthy to usher in a promise for the youths? Can this person give hope to our youth if he is plundering what belongs to them? Mr. Speaker, sir, we have evidence. I rest my case and call upon Mr. Biko to continue with the rest of the opening statement. Much obliged.
Mr. Speaker, sir, without wasting time, Mr. Speaker, honorable members, the book of Ecclesiastes was written by the great King Solomon towards the end of his reign. And this is what he says, that there is a time for everything, that there is a season for every activity under heaven. And he proceeds to enumerate those seasons. And this is what he says, that there is a time to plant and a time to uproot, a time to kill and a time to heal, a time to tear and a time to build. And then he goes on and on and on. Honorable Speaker, honorable senators, the governor is aware of this fact and the wisdom of the words of Solomon. And that is why the governor posted in his official Twitter handle of the 16th day of November 2020 at 3:49 p.m. And this is what he says, that jail me, there is life in prison. Impeach me, there is life after politics. Kill me, there is life after death. His Excellency cannot be far from the truth. Honorable members, we are not going to urge you to kill the governor. But this morning we are going to urge you to do one honorable thing, to impeach the governor of Nairobi for the reasons that my colleague has well enumerated. My colleague has told this House that we have evidence for the charges that have been preferred against the governor. Honorable Speaker, the Nairobi City County Assembly appears before you and your honorable members today, not by mistake, but out of necessity. It has become absolutely necessary that we have a sitting today. And why do I say so, honorable members? I say so because Honorable Mike Mbuvi Sonko has absolutely and completely refused to rise to the occasion and become the governor of the capital city that the people of Nairobi elected him to be. He has, with time without number, confirmed that he does not only lack the mental and moral capacity, but also the intellectual capacity to tackle the problems affecting the people of Nairobi. And we will be demonstrating that to this House. We will also demonstrate how the unending ineptitude of the governor has resulted to loss of taxpayers' money. Honorable Speaker, we are reminded that the Nairobi City County Assembly has nothing personal against the governor. Nothing absolutely personal. But as representative of the people of Nairobi, representing the various wards, we urge this House that by the power given to them by the people that they represent, they've interrogated the behavior of the governor, his leadership skills and styles for the last 3 years, Honorable Speaker. And they've arrived at a conclusion that he is no longer fit to hold that office, honorable members. And that is why when the motion was moved for the impeachment of Governor Mike Sonko, out of the 90 people that participated, 88 honorable members gave it a clean bill of health. And that is why we are before you, honorable members. And so therefore, we have lined 3 witnesses, 3 crucial witnesses, and evidence that we shall be presenting before this honorable court to illustrate to this honorable House of the grounds that have brought the honorable governor, His Excellency Mike Mbuvi Sonko, before this House, Your Lordship, Honorable Speaker. So I will not go into the nitty-gritties. The witnesses that we've lined up, the evidence that we have provided to this House is going to bail us out. And at the end of the day, honorable speakers and honorable members, we shall be urging this House that there can only be one thing that should happen to Honorable Mike Mbuvi Sonko as at close of business tomorrow. And that is Governor Mike Sonko. We shall be praying that he will be impeached by tomorrow close of business. That shall be all for the opening statement. Thank you.
Thank you very much. I now invite opening statements on behalf of the Governor of Nairobi County Government. 30 minutes.
Thank you. Mr. Speaker, sir, and honorable members of the Senate, you have the mandate to exercise your authority within the scope of your standing orders, only if and only if you are satisfied beyond peradventure that the County Assembly executed its mandate before the Assembly, not only within the provisions of Article 1811, but also the County Government Act Section 33 as read with the relevant standing orders of the County Assembly. Honorable members, if any of you were to ask the advocates or any of the witnesses of the county assembly, did you furnish the governor with the evidence you are tabling before us, honorable members? The answer will be fumbling. But if you ask them, isn't it so that Standing Order number 72, sub 2, says that you should provide the governor with the evidence at least 3 days before the debate on the motion? Honorable members, you will find no evidence. You will find nothing that demonstrates, not even in the Hansard from the county assembly, that that mandatory requirement was met. Honorable members, Mr. Speaker, sir, in the result, the bundle that is before you stands expressly barred, which is the position of His Excellency the Governor, by operation of Rule 19 of Part 1 of the 5th Schedule to your standing orders. That is a sieve, the standard against which you, honorable members, will inquire. Has the threshold for the evidence now, County Assembly, you are presenting to us been met? Did you present? Why I say so? Why His Excellency says so, and will insist in furtherance of his objection on a preliminary way, honorable members, is that your own expression by way of the impeachment bill 2018, you had expressed yourselves on the floor and therein stated in section 15(1) of the Impeachment Act that a certificate must be produced before you, Mr. Speaker, by the Speaker of the County Assembly, that there was compliance with that. His Excellency the Governor has sworn a deposition saying I was never presented with any evidence. You will ask, therefore, pursuant to your Rule 19 of Part 1 of the 5th Schedule, is that evidence admissible? Is that evidence that you can look into? It is barred by express operation of your rules. Honorable members, this is an honorable house that is governed and regulated by its rules. And honorable members, I am so happy that, Mr. Speaker, sir, you have issued rulings and directions, Solomonic, to direct, and His Excellency the Governor is humbly requesting that, honorable members, we abide by the rules, of your standing orders, wherein His Excellency is saying the accusations leveled against him were contained in nothing but what, Mr. Speaker, sir, you have in the opening of this session enumerated and said that on the 4th of December 2020, a communication came from the Speaker of the Nairobi City County Assembly. And what did it contain? A, the motion that has the charges. B, the list of the members who allegedly subscribed to that motion. And C, the Hansard that was there. Honorable members, the question is now, that communication did not contain a list of the witnesses that are now sought to be introduced, barred by your Rule 19. You cannot, therefore, look at those documents containing the evidence. You've been told by the counsel for the county assembly. They will call evidence to demonstrate. They will call evidence to demonstrate. Honorable members, I'm afraid, with tremendous respect, Mr. Speaker, sir, Rule 19 of Part 1 of the 5th schedule of your rules expressly forbids, which is the gist and the thrust of our preliminary objection. And you have heard it be told to you that His Excellency, the Governor, failed, refused, objected to assent to the Nairobi City County Appropriation Act of 2020. But they've omitted to inform you in their opening statement that that is a matter pending before court. The Constitutional Court yesterday, as late as yesterday, declared itself before the Honorable Justice Burima, Constitutional Petition E348 of 2020, which again has another hearing date on the 18th of December. Honorable members, His Excellency the Governor is saying your standing orders in Standing Order number 98 3C forbids you from venturing there. And may I remind you, honorable members, you have deference for our court. The judicial authority espoused in Article 159(1) of our Constitution derives from the people. But the County Assembly wants you, honorable members, Mr. Speaker, sir, to trample on that right, on that authority. Mr. Speaker, sir, His Excellency the Governor, by means of his preliminary objection, has stated that his refusal to assent to that Appropriation Act is the judicial authority that is espoused in Article 159(2). Is this honorable House defers that. And yet, cognizant of this very fundamental aspect, Mr. Speaker, sir, honorable members, the County Assembly has affirmed that very position which His Excellency the Governor will demonstrate to you in their own that yellow volume. That should be volume 1. Are annexed the orders of the court showing that the proceeding is alive. And therefore, my honorable, lovely members of the Senate, His Excellency the Governor is saying there are pending proceedings implicated herein. Is it feasible for you, honorable members, Mr. Speaker, sir, to suspend and close your eyes and be and act blind with tremendous respect to the provisions of Standing Order number 98 3C? His Excellency the Governor will beg the floor on a preliminary nature. By virtue of Rule 13, he will move this honorable House, Mr. Speaker, sir, to request and urge you to make a ruling on Rule 13. And Rule 13 of your standing rules in Part 1 of the 5th schedule permits you to grant half an hour for the adjudication of the preliminary objection. Honorable members, the issue will be now, if you are not satisfied, if you see no statement from the Speaker of the County Assembly that there was indeed compliance with the preliminaries of the purported impeachment. Unfortunately, with tremendous respect, honorable members, you have to down your tools. And this is expressed in Section 15 of the Impeachment Bill 2018. It has passed from you, although it is pending before the National Assembly, for persuasion. And then His Excellency will demonstrate and he will show your honorable members, Mr. Speaker, sir, that an issue that is pending before the court that is alive freezes whatever actions that are therein contained. And the pending impeachment motion that was originally filed on the 20th of February 2020 by the named third witness, Honorable Peter Imotok, His Excellency the Governor will demonstrate, has never been withdrawn by operation of the standing orders of the Nairobi City County Assembly. Therefore, His Excellency, the Governor, is saying he has been subjected to an unfair process. That which violates Article 47(1) of our Constitution can never be validated retrospectively, introspectively, or otherwise howsoever. It cannot. It is dead on arrival. Honorable members of this House, let me rehash that on the 24th of September this year, that the High Court intervened in a very crucial aspect of the existence of this House and the life of your tenure. When this Honorable House, as well as the National Assembly, were threatened with, should I say, the truncation of its current term, the High Court intervened in deference to that decision. Honorable members, we are gathered here before you, and honorable members, in 2013 as well. Mr. Speaker, sir, you did ask the Supreme Court to assert the authority of this House by judicial intervention, and it was indeed declared that this Honorable House has that authority that cannot be whittled down, it cannot be otherwise compromised by any writ or any action or even judicial ingenuity. Honorable members, His Excellency the Governor therefore implores and urges you that as we delve into, you give him the opportunity in furtherance of Rule 13 to demonstrate to you that the issues of his alleged commission of national crimes purported in the accusation number 1I, that he is not able to address the same matter sub judice. The issue of the alleged non-funding of NMS, His Excellency the Governor is not able to address on you. He defers to your standing order number 98.3c because the High Court in petition E348 of 2020, Nairobi City County Government versus NMS, His Excellency, I'm sorry, Mr. Speaker, sir. His Lordship, Mr. Honorable Justice Mrima, has stayed the operations of that act, under which, honorable members, the NMS has been claiming funds. How is it then His Excellency can be accused of failing to release funds to the NMS? In all fairness, honorable members, you will see therefore that those charges, 90% of which relate to court proceedings, cannot be incised, removed from, or otherwise extricated from the last paragraph 4 allegations. Honorable members, inevitably, in the end, we have to assess the application of the Rule 19 of this Honorable House Standing Orders to the 5th Schedule, Part 1. Honorable members, so that I yield the last 15 to Mr. Nyamu, my learned friend. I will yield to him so that he can demonstrate to you that what is masked in the position of His Excellency the Governor, what is masked as an impeachment process, it is a witch hunt. For what? Because His Excellency the Governor has insisted being a stickler to the law, just as he is before you. They received the preliminary objection. They know they never filed any evidence. Mr. Speaker, sir, honorable members, they filed nothing before the Assembly because nothing was tendered before you on the 4th of December. Honorable members, you would have scrutinized that by now. You would have known by now. You would have seen and answered by now. You would even have, in minuscule way, your honorable members, Mr. Speaker, sir, seen the veracity of the said alleged evidence. Mr. Speaker, sir, there is one very fundamental aspect. If a man should be denied audience, if a man or a woman should be denied audience when they are faced with accusations and then sentence is passed against them, is that not in violation of your standing order number 75? That every person should be given a hearing, even on county assembly own standing orders. His Excellency the Governor wants to show you in standing order number 72, 1A, there was no compliance. And if a man or a woman should be told, I'm charging you with this, but with no evidence, no court of law would convict them. Mr. Speaker, sir, I therefore urge you to allow us, as His Excellency the Governor is beseeching you, honorable members, that if a matter pending before court, even the county assembly lawyers will be aware to confirm, it is before the Honorable Justice Ndomanderi today at 3 p.m. for a ruling. It's a live proceeding. Does it meet the threshold of standing order number 98? 3C? It does. It does. What do we do in the circumstances? We have to yield. And yield, Mr. Speaker, sir, honorable members, to the standing orders. They advise us. They map the way forward. They are the beacon light telling us we must stay this hearing. I yield to Mr. Nyamo to conclude the opening remarks for His Excellency the Governor, in which event, the last minute, Mr. Speaker, sir, I will come back to request for my application to be considered. Thank you.
May it please the Honorable Senate, as the Senate convenes here, for purposes of considering the motion brought by the County Assembly of Nairobi City County, it is mandated to perform a quasi-judicial role as opposed to a legislative role. This is because these proceedings are proceedings that relate to a matter that may affect the fundamental rights and freedoms of an individual as envisaged under Article 47, 2 of the Constitution. And we'll be urging this Honorable Senate to assume the role of an adjudicatory body when dealing with this matter. To have at the back of its mind that it is being asked to interfere with the fundamental rights of the Governor of Nairobi, Honorable Mike Mbuvi Sonko, under Article 38(3) of the Constitution, which is the right to be a candidate for public office and, if elected, to hold office. It is also being requested to interfere and interrogate a situation as to whether it would interfere with the democratic rights and principles of the citizens of Kenya, and more specifically, the residents of Nairobi. 800,000 of whom elected Mike Buvi Sonko as governor for Nairobi. Honorable members of the Senate, in these particular proceedings, we shall be urging the House to consider that removal proceedings are initiated at the County Assembly and concluded at the Senate. And in that sense, it will not be tenable, and we would urge the court to find so, I mean this House to find so, that anything that was not initiated at the Assembly would be introduced in this Honorable House. We shall be making reference to the letter of invitation that was served upon the governor, which letter referred to particulars and evidence as forwarded to the Speaker of this House by the Speaker of the County Assembly. And it is on the basis of that invitation and the documents that were served upon the governor by the clerk of this Honorable House that a response was prepared. Mr. Speaker and the members of the House, we shall be requesting that this House bears in mind the provisions of Article 50, Sub-Article 2 of the Constitution, where it is provided that an accused person shall have the right to be informed of the charges with sufficient detail to answer to the same, and to have adequate time and opportunity to prepare response. In this particular case, as at the time of invitation, and as at the time the governor was required to respond, the only material that he had was the notice of motion and the documents that are listed in our response. Yesterday evening, after having filed the response, we collected a bundle of documents that had been introduced, which included a written statement by the mover of the motion, which had been amended, which was tantamount to amending the motion, as the same had annexures. It goes without saying that by the time the mover of the motion was initiating that motion, he had these documents. He had these documents, and for that matter, he ought to have relied on them at the County Assembly. As I finish, I would urge this House to strictly consider the standing orders of the County Assembly as referred to in the Section 14 of the County Governments Act, where that particular assembly has to be guided and bound by its standing orders. And that's how standing order number 72, 73, and 67 come about, where the procedure and the documents that ought to have been, the evidence, which provide that evidence ought to have been provided at the inception of the motion. We shall be urging this Honorable House not to allow any additional documents, and the same would be tantamount to the amendment of the motion, in which case this particular House would have no jurisdiction over. On matters procurement, as I finish, I wish to state that matters of procurement, the County Assembly shall be called upon to demonstrate nexus between what happened in procurement and the governor, as the governor is also an accounting officer. At this point, I would be urging my learned friend, Mr. Ondieki, to conclude. Honorable members. Thank you, Mr. Speaker.
Honorable members of the Senate, this is the biggest court in the Commonwealth, because today, as you see it as the biggest court, which will perform a judicial function, which means procedure is critical and very important. I wish to urge you that the Senate has protected devolution. The Senate has provided leadership. The Senate has protected democracy. So we urge this Senate, as you sit as the High Court, as a Supreme Court, to ensure that the procedure, the legal procedure, because the County Assembly is bound by Article 10, it is also bound by Article 47, that the procedure must be law. This, I also wish to submit that there is no proper notice of motion before the Senate that it will warrant an inquiry for impeachment, because the County Assembly flouted all their rules. They flouted all their standing orders. They flouted the Constitution. And that is why we are saying the Senate, as the protector, promoter, and the defender of democracy, defender of the rule of law, defender of constitutionalism, must stop this on the tracks. Let this motion go back to the County Assembly. Once it is properly formulated and it follows the procedure, then it can land back to your desk. Yes. I do not want to repeat, but I also wish to submit that the doctrine of separation of powers is very clear. So if the courts are inquiring and the courts are independent institutions competent to inquire, then it is only fair and just within the context of Order number 98 of the Senate Standing Orders that there are active cases that are going on in the High Court and the lower court. It's only fair and just that this is allowed to be concluded, then these matters can be properly addressed depending on the outcome of those proceedings. The Honorable Senators, I wish to take you to Pontius Pilate. When he went to sleep at night with his wife, the wife told him that that man is innocent. So the following day, he had a chance to release one person. There were two people, Barnabas and Jesus. So when he said, whom do you want me to release? The people shouted, Barnabas.